start this evening with reviewing what we had on limitations of damages. When I looked back over this chapter of Litvinoff's on limitations, it was, to my mind, in some ways enlightening and easier. When I explained to the evening division students about limitations on damages, the ones that we listed were what? Limitations on damages. Mitigation, right? Two, certainty of amount. And three, foreseeability. Right? Okay, those are the traditional ones. But in looking over this, I think that Litvinoff actually added a couple of others, and it was a little easier. So that a little easier to put some of the civil code topics in context as a result. So we started with, last time, with failure to mitigate, right? We looked at failure to mitigate when the non-breaching party fails to take reasonable steps to minimize his losses. His damages may be reduced. That's Article 2002. And we looked at a case about a skating rink, right? Remember the skating rink where they didn't dig around? We also had previously discussed electrodata, and that was a failure to mitigate case. As a matter of fact, if you look it up in the sub-insights, that's what it's still primarily cited for. The obligee's bad faith or fault. The obligee's bad faith, not the obligor's bad faith. The obligee's bad faith. If the obligee himself does something that intentionally that causes the obligor to fail to perform, he cannot then sue the obligor for damages, right? So we can add that to our list. Obligee's bad faith. And where did we have that? We had that in the Al Copeland case, where Al stops building the restaurant but still wants the developer to pay him. There's a similar topic that we studied when we were talking about failure to perform or breach of contract. If you are not ready to perform, you can't sue the other party for breach, right? If you are in default, you can't sue the other party for breach. This obligee's bad faith is right in there with it. Okay, and so here Al Copeland had bad faith in not continuing the building, so therefore he could not sue the defendant. And there are also, we talked about contractual limitations on damages. So limitations per contract. That's not the same as stipulated damages. With stipulated damages, the parties stipulate a certain amount of damages. But with limitations on damages, they limit or shift the damage amounts from one party to another. There's no problem with this. In general, parties may agree to limit or reallocate damages among themselves. But the Civil Code gives a limit on that, when they cannot do that. Article 2004. You can't do that if you're trying to exclude one party's liability for intentional or gross fault. So you can't limit one of the two parties to the contract. You can't limit his liability for intentional or gross fault, nor can you limit a party's liability for causing physical injury to another. In other words, we're all responsible for our own negligence. That you can't shift. There are times when, especially in commercial contracts, there will be some kind of shift. So very often in a commercial lease, there's a provision saying that the owner, the landlord, will not be responsible for injuries to third parties on the premises. Okay, what that means is that in most instances, the tenant has to indemnify the landlord, okay? Except if it's something that the landlord caused and he knew about it. So, for example, if we've got the lease of a building, it's being used as a grocery store, okay? The tenant is a grocery store. The tenant does not make sure that its employees pick up banana peels and wipe up the floor. Some little old lady slips and falls. Lawsuit, right? Okay. Is a landlord, is a shifting away from the landlord a problem in this case? If there's a clause in the contract, in the lease, saying that the tenant, the grocery store, will indemnify the landlord for damages, is that a problem here? Okay, is the landlord responsible for anybody slipping and falling on a slippery floor? Can the landlord do anything to stop it? Could the landlord see it? No, the only party who could actually see it would be the tenant, the grocery store people. It's their responsibility. On the other hand, we still have that same clause saying that the tenant will indemnify the landlord for third parties. That doesn't apply when it's the landlord's own negligence that caused the problem. So there's an old case. Some of you are old enough to remember Katz and Best Off drugstores, or a Louisiana favorite for many years, until they were bought by, was it CVS or Rite Aid? It was Rite Aid? Okay. They were known for their, what is it, purple and white. They had my Northwestern colors. Northwestern University is purple and white. There's a K and B purple. In any case, there was a K and B at the corner of Napoleon and St. Charles at one time. And apparently the tenant notified the landlord that the stairs were rotten. The stairs going down to where the customer bathrooms were. Some little old lady hurt herself when the stairs collapsed underneath her. So is K and B the tenant going to be liable, or is the owner going to be liable, or both? The owner. Well, both the little old lady, but ultimately it's the owner's fault. So the owner's going to face. Okay, so that's what they're talking about when they're talking about limitations of liability as per contract. Then Litvinov talks about proof. Proof of damages. Ties us back to number 2, okay? You have to prove damages to a reasonable certainty of amount. We don't see that in the Civil Code, but it's part of the long-standing jurisprudence, and that actually is very consistent, completely consistent with common law. But there is some room for the judge. If damages are insusceptible of precise measurement, then the court has substantial discretion to adjust the damages. And we looked at a case like that, and that case was the janitorial case, Hall versus Arkansas, where the janitorial company is suing the building for failure to give them 21 days before notifying the contract. We don't know the circumstances. It seems very strange that the defendant building owner is found liable for this because the building burned down. I'm sure that if the building owner had known, he would have called them up and say, well, 21 days from now, we're going to burn down the building. That doesn't sound right. So it sounds to me like the contract should have been dissolved for force majeure. But in any case, the trial court finds the owner liable for damages, and then the question is, well, how much? The trial court listened to what the owner of the janitorial services testified to. He didn't bring any supporting paper with him, and just said, well, 60%. I think we'll just give it $25,000, and another $5,000 for attorney's fees, right? And the appellate court said, no, we don't do that. Okay, you have to establish the amount to a reasonable certainty. And this guy just got up on the stand all by his little old lonesome, and he didn't back up anything that he was asking for. There were no business papers, no documentation. What you need is paperwork that you do on a daily basis. He didn't bring that, so the court struck the damages. And you cannot get attorney's fees except by contract or by statute. Set by contract or by statute. So then that was the limitation called proof of damages. Then we talked about stipulated damages. The Civil Code has a whole section on stipulated damages. Stipulated damages are where the parties in their contract stipulate how much is going to be given should one or the other party breach. How much will be owed. It may be a way of calculating it, or it may be a specific amount. You know, $500 per day for every day you don't vacate the premises. Okay, that's an example of a stipulated damage. Louisiana, unlike common law states, favors stipulated damages. If you agree to it, full freedom of contract, if you agree to it, that's what you pay, unless it's so manifestly unreasonable as to be against public policy. I haven't seen one of those yet. Okay? There are a few points to learn with regard to stipulated damages. It's Articles 2005 to 2012. If there is a stipulated damages clause, the obligee can demand either specific performance or the damages, but not both. Okay, but that's fairly standard. You get fixed one way or another. You don't get two fixes. So either the stipulated damages or the specific performance. He cannot demand stipulated damages if the failure is justified by a valid excuse. And we looked at one like that, right? We looked at an instance where failure was justified by a valid excuse. What was the valid excuse? Well, the plaintiff, the state, was the one that caused the delay. Okay, so the contractor couldn't finish on time because of the state's delay. Remember, there was only 15 days left after they subtracted the state's delay. The obligee also need not prove actual damages. If there's a stipulated damages clause, you don't have to prove that you were damaged by the breach. All you have to prove is the breach. Okay? All you have to prove is the breach. Again, that's a bit counter to common law, because common law wants to make sure that a stipulated damages clause is not penalizing the breaching party. It's not more than a penalty. It's not intended to be a penalty. It's just more or less equivalent to what expectation damages would be. The non-breaching party may not avail himself of damages for delay, stipulated damages for delay, unless the other party's been put in default. And the amount of stipulated damages for, again, non-performance may be reduced in proportion to any benefit the obligee received. That's Articles 2010 and 2011. So make sure you read them and understand them. So we looked at the two cases. There was one, Lombardo versus Des Hotel, where the guy he'd written a contract, the seller of the realty had written a contract that said, I either want specific performance or I want the $1,000. And then when the guy breaches, he says, well, I sold it to somebody else, so what I want is the difference between what I sold it for and what you were going to buy it for. And the court says, no, you limited yourself to a choice between specific performance and keeping of the deposit. When you sold the property to a third party, you denied yourself the availability of specific performance. You can't sell something you no longer own. Okay, so therefore it's $1,000 for you. And okay, then we had the 5 times daily rent. The court said that was not manifestly unreasonable. Then we looked at a section called, they called it quantum merit, but I prefer to call this section gap filling. Gap filling. Okay. We've talked about quantum merit before, But this is referring to Articles 2054 and 2055. 2054 says that if the parties forget to put something in their contract, okay, and that hole is causing a problem, then the court may imply that they intended to encompass anything that in law, equity, or usage would be in a contract of that sort. Okay? What is law? We know what law is. Equity is fairness. Usage is those kinds of contracts, what's usually in that kind of contract. So the case we looked at was the Canal Place case, where the electrical contractor forgot to put in how much he wanted to be paid. So the court looks at, well, what's typical here? Oh, you guys have dealt with each other before, so what did you do before? Oh, $75 an hour, there we go. How many hours was it? You kept records? Good. Okay, 75 times the number of hours, and we're done. Okay, so in that case, the court filled the gap. The parties did have a contract, they just kind of forgot to put something important in there. Then we talked about recovery for obligations that arose without agreement. Okay. What does without agreement mean? Obligations that arose without agreement. Yes, Mr. Hatfield. They never completed the formation of the contract, or they never had a contract. Okay, and there are actually 4 kinds that they look at. One they don't, Liffinoff doesn't really discuss here, but it's detrimental reliance, right? 1967 is the article number. We talked about that, right? There are 3 elements: a promise, such that the promisor expects the promisee to rely on; reliance that is induced by that promise and is reasonable; and no other remedy. No other remedy means, oh, this arose without agreement, without a contract. Detrimental reliance. Negotiorum. Gestio. Okay? There's no agreement in a negotiorum gestio. That's the busybody thing, right? It's when someone acts for another person in the reasonable belief that that other person would want him to do so if he were around. So he's acting as the owner's unappointed agent. Unappointed agent. And we talked about cases where you have a broken window on your neighbor's house. You know he's out of town, so you get it boarded up. If you choose to do something, you have to do it as a prudent administrator. Prudent administrator is a fairly high standard. It means you do it the way you would want it done if it were yours. Prudent administrator. So, and if you don't do that, then you may be causing damage and you'll be liable for that. You need to notify the owner in advance of doing anything, if at all possible. Okay? If at all possible. If all of that is in place, then the owner is responsible. Now, mandate articles apply. Mandate is where you're acting as somebody else's agent. If you're acting as their agent, you can represent them on that issue in court. And we see that in the standard motor car case. Standard motor car case, the car repairman, remember he fixed the car, driving around in it, gets hit by the defendant's insured, fixes it again, and now wants to be reimbursed for his expenses. And he didn't want to go to the owner, put the owner to this trouble because, you know, he is acting as a depositary, he's supposed to take care of it, doesn't want to bother the owner. So the court says, well, essentially you're acting in negotiorum gestio. We can completely understand that. And since you're acting as the owner's representative, then the insurance company can't say anything like, well, we don't have a deal with you. We didn't commit a tort on you. Well, you did on my principal. I'm the agent, the mandatory, says the car repairman, for my principal, the homeowner. Okay. Does that make sense? Yes.
And is a mandate the same as a gesture?
Yes, mandatory. Yeah. The mandate is the actual agency. Okay? The agent is the mandatory. The principal is the mandator. You're not probably going to be tested on that because that comes in business organizations. But as I tell my sales and lease students, you're going to be tested in Code 3 on contracts, obligations, sales and lease, and secured transactions. Sometimes it's hard to separate these things out. So as I teach these courses, I try to teach the links. So we've been talking about suretyship, and now we're talking about mandate, so that when you join it with the other course, you'll be able to put a seamless web of your knowledge together. Okay, none of this will seem so strange. If I just kept saying, oh, well, suretyship, don't worry about what that means, you don't need to know that till you take secure transactions, then you wouldn't understand half of what we're talking about, or a third of what we're talking about, or an eighth. And when you got there, you wouldn't be able to tie it back to obligations. So I try to create these little linkages so that you'll be able to put them together later as your studying goes on. So negotiarum gesture we talked about. We talked about enrichment without cause, right? That's the Louisiana term for unjust enrichment. Now, the Louisiana Civil Code term is enrichment without cause. The common law term is unjust enrichment. In Louisiana, they're still by the courts used pretty much interchangeably. Okay? When one person is enriched to the detriment of another person, okay, that person who suffered will be reimbursed to either the extent of the person's enrichment or the extent of the deprivation, whichever is less. The amount of compensation is measured by the extent to which one was enriched or the other impoverished, whichever is less. And the code oddly leaves time as to when you can measure it, either at the time the suit is filed or at the time of judgment. And we looked at Gulf Stream Services. And this one was a little confusing in a way because it looked a lot like the Canal Place case. In Gulf Stream Services, the defendant calls up the plaintiff and says, I need a couple of hot oil tanks fast because the Coast Guard is on my neck. They're telling me I'm not storing the oil safely. I'm not up to EPA standards or whatever it was. Please get them to me as soon as possible. No, I can't pay that. No, I can't pay that. We'll have to talk about exactly how much we'll pay, but just please get me the tanks. All right, we'll get you the tanks. Something like 3 months later, the plaintiff says, oh, you brought back my tanks. Thanks, that's very nice, but I do need to be paid for the time you had them. And so now we have a disagreement. And there was never a contract because they never actually agreed on pay. Okay, so they hadn't really reached a yes. In contrast to the Canal Place where they said, oh yeah, we got a contract, it's all written. Okay. Here, the court says, well, you were unjustly enriched by those tanks. You didn't object to the $75 a day times how many days. Okay, that's how we're putting together the damages. That's the amount you were, the other person was impoverished per day. There's also an article right after the unjust enrichment. So this is 2298 is enrichment without cause, and 2299 payment of a thing not owed. Just from reading the title of that article, you can pretty much anticipate what it's going to say. What do you think is going to happen to somebody who's paid something that was not owed to them? Pay it back, okay? And that's what our nurse had to do, right? Okay, pay it back. Okay, so she had to reimburse the overpayment. Now, I thought that was pretty much, I squeezed into the evening division, the non-pecuniary damages. But I know sometimes this is confusing. So I'd like to just go back over those cases tonight and see how you're doing on them. Okay? Mr. Hatfield, are we okay with that? Okay. I thought that we were scheduled to get it to about page 196 this evening. That's what my syllabus said. 496, that's what I meant. Supposed to be like 527 today. Okay. Okay, well, that's not what my syllabus says. My syllabus says this is March 19th. Okay, am I looking at the wrong syllabus? Because, oh, this is March 19th. Mine says 466 to 496. Okay, well, let's see how far we can get, okay? No wonder I'm confused. Okay, no wonder I'm confused. But that means you're all ready, right? Yes. Okay. What about the day students? Are you guys ready too? Don't do me this. We're not going there again. Okay. Are we on the same page, day students? More or less?
You told us.
496.
Yeah,
Okay.
but you told us 5.
Okay, well, we're going to go forward and see where we get to, okay? Somebody tell me about non-pecuniary damages. What are non-pecuniary damages? Miss Portia, what are non-pecuniary damages? Do you need an article?
Yeah.
How about Article 1998? See if that's a good one. It says damages for non-pecuniary loss.
Damage for non-pecuniary loss may be recovered when the contract, because of its nature, is intended to gratify a non-pecuniary interest, and because of the circumstances surrounding the formation of the non-performance of the contract, the obligor knew or should have known that his failure to perform would cause that kind of loss. Regardless of the nature of the contract, these damages may be recovered also when the obligor intended through his failure
To aggrieve.
the feelings of the obligor.
Okay, now, aggrieve. Can you tell just by the way it's pronounced what that means, to aggrieve the feelings? What does aggrieve the feelings mean, Miss Portia? Context should help you. The word grieve should probably help you. Miss Gentry, you want to?
I would think of like sentences like I would think like aggravated, like
Deliberately wanted to hurt. Right? Deliberately wanted to hurt the other person's feelings. Okay, so can you guys put that in your own words? Because reading it is just words. It doesn't mean anything. I need you to put it in your own words. How many elements are there in a cause of action for non-pecuniary damages? How would you divide it? You say 2?
yeah, because I look at it like the contract is for non-pecuniary,
Interest,
and then the other half
new,
or should have.
right. And we could add a third one, the agree the feelings, regardless of the nature of the contract. Okay. Now, you have to note very carefully that the article says the contract, because of its nature, is intended to gratify. Because of its nature is intended to gratify. So the first case we looked at involved a truck. Is there anything that about a contract to buy a truck that because of its nature is intended to gratify an intellectual interest? Okay, now the issue is, be careful here, because we look at later language in this chapter, and they're talking about the object of the contract. Okay, is there anything about the object that is intended to fulfill a non-pecuniary interest? With a truck, right? For fishing. Is that object or is that cause? Ah, okay. Big difference. The object of the contract is intended to fulfill some sort of intellectual interest. A truck would never qualify. Now, on the other hand, I would say never, but there's probably, if you look at comment C to 1998, what does it talk about? Fraud. What else? Gives an example, doesn't it? Let's see examples. Something is sentimental value, something fulfills an intellectual interest, something about a horse, of course.
Yeah. So, like, if you would have bought the truck, say, for instance, like a car show.
Right. Or if you bought a Corvette because you were joining a Corvette club. Okay? Then I think you'd have a stronger argument. Okay? Then you'd have a stronger argument. It was clear with the dresses from D.H. Holmes when the wedding dress was 4 inches too short, right? Why do people buy a wedding dress? Is that for an investment? Heck no. Okay? It's not worth whatever you paid for it the minute you put it on, right? Nobody else is going to buy it for you, or if they will, it's at a substantial discount. Okay? The airline case. That's a little difficult, right? National Airlines. Yeah, with the vacation. So what happened with this vacation? Whole bunch of things. They're supposed to fly first from New Orleans to Miami and pick up a cruise ship, right? Probably have a nice romantic evening at a hotel the night before. Generally, if you want to take a cruise, you do not want to arrive there the same day because something happens to your flight, you miss the boat, literally. Okay. So apparently they were going to get there the day before and then leave. What happened? Stopped in Pensacola. Unscheduled stop due to really bad weather. Wife who doesn't like flying says, I'm not getting on the plane again, rents a car and drives. Hubby waits for the new flight, right? Gets there, but she never does, and they miss the boat and come home. And so they sue for non-pecuniary damages. Do they win or do they lose? They won. They won. Now, I tend to have a problem with this because it's a flight. It's an airline flight.
Wasn't the catch though that the stop in Pensacola was supposed to be on the plane's way to New Orleans, and the plane had stopped without telling them it was going to stop?
Yeah, they were supposed to have a non-stop flight.
Right.
Without notice, it had to stop.
The Pensacola stop was supposed
Well,
to be on the way to them.
yeah, but I thought the problem was the reason they had to stop was due to weather. It was a very,
Yeah, it was.
Yeah.
They couldn't stop on the way to New Orleans.
yeah. So is that the airline's fault? Would you rather they had flown and tried to stop earlier in Pensacola and crashed? I mean, those are the choices with airlines. You know, we all know they're canceled for weather, right? Even the 1950s when this was written. I remember I had shortly before come to Louisiana. This was what, 1979? I was teaching dancing in Kenner and heard a boom and saw smoke. Do you remember? Plane crash due to wind shear. It was 81? Okay, it was wind shear. So we all know that planes, so should an airline suffer for non-pecuniary damages? Did they intend to aggrieve the feelings of the plaintiffs by stopping? No. Right. Is there anything that the airline knew or should have known that they were flying in order to take a boat, a cruise ship? A vacation package, but aren't those put together by travel agents? Yeah, they're separate, but you don't usually know when somebody gets on a plane, oh, this person's got the package, the person right next to him is just flying to Miami to see Cousin Joe. Okay? How would they know that? There's no way they would have known that. So I think that here, this was a miscarriage of justice because the court was just very angry at the rude way the airlines handled it. Okay? But that in another case, they should not have been awarded non-pecuniary damages. Okay. We talked about the buried in the wrong plot case, right? She got nominal damages. They tried to fix it as soon as they could. They didn't intend to hurt her feeling. Got $100, which was more than it is now. So finally, now we get to Nolan. This is the Nolan case. And this is a little more, I think this is a little more interesting. Yeah, I don't think we talked about this one. What happens in Nolan? We'll still get to about 521, I think. This is the insurance guy. So what happened with our insurance guy? Well, if he poached and tried to move their clients to a different company, he'd lose all of his commissions. Okay. And so they think he's doing that, right? That's what they say. And what did they do? Sneaky, low down, dirty, nasty people that they were. They falsified documents. So they did that. Would you call that bad faith? How do you define bad faith? This is a difficult one. Can you define bad faith? We talked about doing something intentional and malicious, right? Let's talk about other definitions as well. People have talked about bad faith is hard to find, just like, but you know it when you see it. Kind of like pornography, it's hard to define, but you know it when you see it. But I think a better definition is depriving the other person of a benefit that they expected to get from the contract. Doing anything to deprive the other person of a benefit they expected to get from the contract. The Uniform Commercial Code defines it as lying. Pure of heart, empty of head. I didn't know it was a falsehood. Okay. So here the court says, well, this was in bad faith. So what do you remember about bad faith damages? How do they calculate bad faith damages? This was a breach of contract. They weren't supposed to accuse him of something he didn't do. So what would be the measure of damages for bad faith? Mr. Carlos? We studied this a couple weeks ago. If you breach a contract in good faith, you're liable for foreseeable damages. If you are in bad faith and breach it, you are liable for,
If you're in bad faith, anything that's foreseeable or not, as long as it's a direct consequence of the.
absolutely. Okay, so I gave you the proper key and there it was. Okay. So all damages foreseeable or not that are a direct consequence of the failure to perform. So the question in this case is, okay, we've got bad faith, we've got a breach. Mr. Nolan says, this was horrible. I was crying. I needed Prozac. I want non-pecuniary damages and attorney's fees. And the lower court, I think, said yes. What does the Second Circuit say?
No evidence of foreseeable pecuniary loss within the allowance of damages.
Okay, it says, with regard to the unforeseeable pecuniary loss, which would be clearly within the enhanced allowance for damages for bad faith, he presented no evidence of unforeseeable damages that were above and beyond. Okay? Now, when it comes to non-pecuniary, is there anything here that showed them that they were trying to deliberately hurt his feelings? No, they're just trying to beef up their case against him and say they justifiably didn't pay him, right? What, Mr. Hatfield?
So what's the? I think I understood how they was trying to. What's the difference? How do you know that fine line is between not trying to hurt his feelings and cause not
Well, there is no direct animus. They're just trying to save their own skin, okay? Is this the kind of contract? Is the nature of this contract such that its breach is liable to cause non-pecuniary loss? Is the object of this contract one of an intellectual enjoyment? You say yes?
No. I'm saying I get what you're saying.
Okay.
I understand.
Okay. Oh, yeah. Okay. I like nodding in agreement with me, but not when I'm.
Yes or no question is supposed to be no.
So this is a plain old insurance contract. Remember, you have to look to the nature of the contract. Okay? Just because they breached it in bad faith, that doesn't change the nature of the contract. So no non-pecuniary damages. Is there anything by contract or by statute that said that he could get attorney's fees? No. Okay. So you don't talk about non-pecuniary damages as part of bad faith because it is not. Okay? Unless we've got the lady with the wedding gown and she deliberately messed up the wedding dress because the bride is engaged to the seamstress's former boyfriend or something. Okay. Right? Okay.
So
Yeah.
you do not discuss bad faith damages with non-pecuniary damages unless the person's breach was in bad faith that looking upon non-pecuniary interest.
Right. Look at the nature of the contract first. The nature of the contract is not one designed to fulfill a non-pecuniary interest, then no non-pecuniary damages. And it doesn't matter whether you've got good faith, bad faith, or no faith. Okay? Yeah.
The nature of the contract, that phrase just gets me every time. So is it?
I know. That's why I was going over it.
Or the I know.
It's more often the object. You'd have to present a stronger case for cause. So if we take, like we took the truck, right? What is non-pecuniary about the purchase of a truck? Generally, nothing, right? But if the guy walks in and says, I need a truck that I can compete in monster truck competitions, and I want it painted blue with black polka dots, with a big green stripe running down the side, and teeth showing out the front. And now we're talking about something that might have some intellectual enjoyment to it, I guess, if you like that kind of thing. Sometimes it's fun to think about the ugliest thing possible. Does that make sense to you guys, Mr. Villari? Okay, you think you can, Miss Montgomery, you feel better about? Yeah, okay. Yeah, I thought looking at the language in the cases where they're talking about the object was not intended to fulfill a non-pecuniary interest, that's clearer, okay? Okay, the next is interpretation of contracts. Article 2048. Litvinoff talks a lot, but there's only one case on it. And this is something that I have seen tested on the bar exam, okay, verbatim. So let's look at this. Interpretation is determining the common intent of the parties. This should sound familiar. If you're interpreting a statute, you're trying to determine what? What it was intended to do. You look at the language. If the words of a contract are clear and unambiguous, no further interpretation. Did we do this before? Yes. Easier now, right? 2045. It's in the section called, accurately enough, Interpretation of Contracts. Common intent of the parties is the first one. If the words are clear and unambiguous, we stop. Generally prevailing meaning, or if it's a technical word, then the technical meaning. That's 2047. 2048, if there are different meanings, then the one that best conforms to the object of the contract. If it's a provision that's susceptible of different meanings, it has to be interpreted in a way that's effective, not ineffective. Interpret things in light of each other. If it's in general terms, then it must be interpreted to cover only those things the parties intended. If they intended a contract of general scope but included a provision that describes a specific, you don't narrow it down to the specific. Here we go. Nature of contract, equity, usages, conduct of the parties, contracts between the same parties. You can use those too, right? Gap filling, 2054, 2055. This next article, 2056, we sort of look at indirectly. Standard form contracts. Common law in the Dark Ages used to say, oh, well, this is a contract of adhesion. You sign it or don't sign it. It's not going to get changed. That's an evil thing. It shows that there wasn't bargaining power and there wasn't back and forth negotiations. But that's not the case anymore. But in case there's a doubt, we're going to interpret it against the one who provided it. Okay. Generally, we all sign form contracts as a matter of everyday practice. It keeps costs down. There are times when you can actually pencil in a change. There have been contracts professors who have sent things back, contracts back to, like FedEx, with their initial changes. I reject this clause, I reject that clause, which is what you normally would do in negotiating a contract. Unfortunately, FedEx or whatever it was never answered, so they didn't get their contract at all. Okay. Again, in doubt, interpret against the drafter or interpret in favor of the obligor. Okay. The only case that we have in this section talks about, this is Aguillard versus auction management. Okay. Aguillard versus auction management. And what happens here? Page 498. Page 498. Aguillard. Mr. Francis?
This one, can I ask? I know it deals with the auction of property. I don't think I have
A good enough grasp of it? Okay. Mr. Hatfield?
I'll take a swing at this.
Okay.
There was an auction of real estate,
It's a
then there was auction of real estate.
Mm-hmm.
And the terms and conditions included an arbitration clause. The plaintiff had to, I think, sign it. It was a form contract. The plaintiff had to sign it before he could go in there, and the arbitration clause was in fine print. The plaintiff submitted the highest bid.
And then the defendant, seller, says, I'm not selling it for that low amount.
and then submitted a high counteroffer. The
Right.
plaintiff balked at that, it sued, and the defendant filed a motion to stay, so there'll be time for the arbitration.
And the plaintiff wants to stay in court. So the issue then is this arbitration clause enforceable?
And the Court of Appeal said that the contract was adhesionary, and
Right.
because of the arbitration agreement, went to the Supreme Court. Plaintiff said, it was fine print, it was ran down the road at this time, and whatever excuse they had. The defendant said they raised their positions that signatures are not mere ornaments, and the court decided basically that the bargaining position of the drafter was not so much greater than that of the plaintiff, and that the scope of the clause was failed to cover the issue of dispute over to invalidate the arbitration clause, and apparently this clause failed to cover this kind of dispute.
Okay, the court is also, why did the court hear this case?
Because there was a split, there were 4 circuits.
Absolutely. The circuit split. Some were for arbitration agreements and some were against. And in light of the fact that the United States Supreme Court is in favor of arbitration agreements, you could sort of see which way the wind was going to blow. But what the court says is, as Mr. Hatfield said on page 504, the signatures are not mere ornaments, but they were also looked at at how it was written and where it was. They say, page 503, the second full paragraph, the last sentence. The arbitration provision, though not distinguished, was not concealed in any way. It was contained in a single sentence paragraph separated from the preceding and following paragraphs. Remember I told you each obligation in a contract should be in a separate paragraph. So this was. It wasn't buried somewhere. Pardon?
It was the same font. It wasn't like.
Right, it wasn't any smaller. It was the same font. It wasn't any smaller. And nowhere in the document do defendants reserve to themselves the right to litigate any issue arising in the contract. The reservation of rights within the default provisions can only be invoked when the purchaser fails to comply. So it doesn't see that they say there wasn't a bargaining disparity here. Okay? So it's enforceable. But it is interesting to look at because they do go through some of the contractual interpretation things in terms of what you look for to see if something is unfair. Remember, if it's unconscionable, that means there's widely disparate bargaining power in terms that are grossly unfair to one party. We don't have that here. Okay. Last time I talked a little bit about kinds of obligations. Articles 1763 and 64. This gets a little bit tricky, but I very much want to get up to, if we can, and I'm delighted that you guys are so well prepared. I very much want to get up to suspensive and resolutory conditions for Wednesday because those are tricky. This is not. This is not tricky. These kinds of obligations. A real obligation is a duty correlative and incidental to a real right. That's tricky. That doesn't sound right. This is Article 1763. The effects of a real obligation, it's transferred to the successor who acquires the thing, and the successor can liberate himself by abandoning the thing. That's 2064. The next kind are strictly personal and heritable. Heritable obligation, most obligations are heritable. That means you can transfer it to a successor. Every obligation is deemed heritable as to all parties except when it results from either the terms or from the nature of the contract. Okay? So in order for something to be a real obligation, in other words, to go with the thing, you need some specific terms in the contract. In order for it to be strictly personal, that means to go with the person only, that particular person. Generally, it's by the nature of the contract. We talked about painting somebody's portrait. Okay, the painter agreed to paint your portrait, not that of your dog. Okay, you're hired for a specific person, or you hired a specific painter. You don't want me painting if you hired my grandfather. Okay, so Bro versus Laird. Bro versus Laird. The facts, I think, on this one are a little tricky. Okay, so let's see if we can draw them out. Everybody's got this, right? Okay. Bless you. We have the plaintiff who buys a home from Belfair, right?
Who is Laird? I never found the name Laird.
Never found out who Laird is.
Okay. We don't know.
We don't really need to know. It's probably the CEO of one of these companies. Okay? Mid-States. He bought it from the developer, right? This is the contractor, the general contractor. And Mid-States had contracted with a surety. Okay. The house is bad, right? So this is a contract for a home. So the plaintiff sues the surety. And the surety essentially says, I have no idea who you are. I don't have a contract with you. Why are you suing me? Okay. If we go back and look at the contracts between the parties, Bel Air and Mid-States. Is it Bel Air or Belfair? Belfair hired Mid-States to build 53 reinforced concrete homes. Okay? The contract provides blah, 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 and it says that has to be bonded. Mid-States has to get a bond. Remember, licensed, bonded, and insured? This is the bond. So you have to get, Mid-States, you have to get a surety to guarantee your work. So if your work isn't good, the surety is going to come in and provide the money to make it good. Okay? That's what bonded means, licensed, bonded, and insured. Okay? So this is a surety's job. And the contract here says all the agreements herein contained, second to the bottom paragraph on page 507. All the obligations herein assumed shall inure to the benefit of and be binding upon the heirs, successors, and assigns of the respective parties thereto. Okay? So whoever owns the house hereafter, if it wasn't built right, can sue them. If you look at page 508, here's some helpful language, third paragraph from the bottom. Not only the obligation, but the right resulting from a contract relative to immovable property passes with the property. This is like a servitude. You guys haven't had property yet? The Day Division has had property?
Yeah, we haven't gotten to servitude yet.
You haven't gotten to servitudes? Okay. A servitude is a right. You may own the property, but somebody else has a right on that property. So, for example, they say, call before you dig. Why are you doing that? You might hit the power line. That means the power company has a servitude across your land. Okay? So they have a right to use that path to maintain it. Okay? So these kinds of rights are like a servitude. A real right is like a servitude. It goes with the thing. You don't want to be obligated, then you can just get rid of the thing. It's a little easier to understand because I think the language on this one isn't that clear that it's a real right. It's clearer when we get to McGuffey versus Weil. Okay? We have, let me see, I hate to move. You guys have this? Can I erase this? Yeah? Okay. You with us, Ms. Tordoff? Okay. Stubbs had a piece of property that he sold to a bank, which then sells it to McGuffey. Okay. Now, where is this property? Monroe. I've never been to Monroe. Are these streets familiar? To anybody who's been up there? Okay, it's at the corner of North 3rd, and this is named after Stubbs. Okay. So Mr. Stubbs puts in an agreement with one of the first people he sold to, Goldman. Was it Goldman? Yeah. The following language. Now, therefore, it's the middle of the page, in accordance with the appearer's representation to the said Solomon S. Goldman, whose representation, part consider blah, 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 does hereby covenant and agree and does hereby bond himself, his assigns, heirs, and executors, as well as, this is much clearer, all future owners of the certain lot or portion of the ground hereinaf described, okay, so that said property shall only be used for residential purposes, and all dwellings erected must be so erected as to face Stubbs Place. Okay? Okay, so this is the lovely corner property, and what is it that Mr. Stubbs wants for forever?
Residential, facing in off street.
Residential. House. House. Wants a house, and the front door has to face Stubbs. Why do you think he wants it to face Stubbs Place? Yeah. Well, maybe not that big, but at least he wants a street named after himself for forevermore. Okay? Doesn't want it turned into an alley. So the court says what? As Mr. McGuffey wants to build something, probably a commercial property facing North 3rd. Can he do that? No, he's told no by the court. The court talks about the fact that when it comes to these real rights, they're not really favored. If you don't use them, you lose them. So if nobody had ever said anything and somebody had built something facing North 3rd, then that real right would be lost. But that never happened. And since that never happened, it still exists. And so, no, you can't build anything unless it's a house facing Stubbs. Yeah.
That was the defendant in this case, right?
Maybe that is Stubbs' granddaughter or grandson. This looks like a deck action to me, declaratory judgment action. McGuffey sued because he wanted to be able to build something, and this was not clear. So he wanted the court to determine whether he could possibly end up as a defendant in a suit saying, no, you built the house the wrong way.
Did McGuffey get a copy of the restrictions?
Yeah, because it's in the public record. It's in the registry. Okay? It's in the registry. Yeah. Yeah.
Kind of touched on
Uh-huh.
The other thought that occurred is, okay, this guy died in 19, it's almost 96 years ago. This guy.
Right.
At some point, somebody somewhere might want to put a business face in Third Avenue. So is it the point at which nobody's going to contest it? That
In part, yes. In part, yes, because servitudes can be lost. They prescribe for non-use after, I think it's 10 years.
so in this case, can you give an example of how in this case it can prescribe?
Okay, so let's say that Mrs. McGillicuddy buys the property, doesn't see that, goes ahead and builds a quick stop on the corner, and nobody says anything for 10 years. Okay, then nobody can come back in and yell about it. Granddaughter Weil can't come in and said, you build a quick stop. Tear that quick stop down on the corner. You're 10 years too late. Okay?
Can she do it before the 10 years are up?
She could do it before the 10 years are up. And then there might be a problem, but I'm not going to be questioning you that deeply. This is where it's crossing into property law. Again, this is part of that seamless web I was talking about earlier. Okay? Okay. Yes, Ms. Montgomery.
So you said real rights are like servitudes,
Yes.
but they're not the same in that real rights don't. Do they prescribe it 10 years, or is that only real rights do prescribe?
Just like servitudes, it picks up the law at that point for non-use, 10 years of non-use. Okay. As I remember, I'm not teaching property. I haven't. What I'm asking you to look for is language like that they have in here. Binds himself, his assigns heirs and executors as well as all future owners. Okay, that would be a real right. In the previous case, shall be binding upon the heirs, successors, and assigns of the respective parties. Okay, it's a sign of a real right. Okay, strictly personal. In re minor female child. Miss Jack, did you get this one? Okay.
It was how mom was trying, daughter was foster care, or
Yeah.
they were trying to, she wanted to keep parental rights, and they were trying to terminate them.
Mm-hmm.
And it was an actual
Well, they had been terminated. She was appealing.
Yeah, she was appealing it.
Okay.
Because they were strictly personal. But
Mom was killed.
died while its her appeal was moved. So the family was in bereavement after.
Yeah. So it's who wants to continue the suit? No, Mom died.
The grandmother.
Grandmom.
But it
Okay.
wasn't personal, but since she wasn't the mother,
She had no right. Okay. So parental rights are personal. Well, that makes sense, right? But it's still pretty harsh on the grandparents. Normally, what happens with children who go into foster care? What is the first choice? Family. So if it wasn't grandma when mom was going through this, why grandma now? You know, if it seems so unfair, you can think about it that way. If grandma had been a suitable parent, grandma would have been invited to become the parent when mom botched it, right?
This kid was, what,
3 or 4 years in the foster home, and I always like to look at it from the child's point of view. This child has been in the same foster home for 3 or 4 years. I would hope that they would be trying to adopt. So the more you move kids around, the worse it gets. Okay, Bogart versus Caldwell. We just saw something that was a strictly personal right. Bogart versus Caldwell. Does this one involve a strictly personal right or not? No, we've got a death of husband here. Mr. Miguez.
Bogart was the owner of a movie theater and suing, I guess, Caldwell, who opened another movie theater.
Well, yeah, Mrs. Bogart is suing Caldwell, who opened another.
So I'm a little bit confused.
Okay.
I guess she owned the property.
Well, what happened was that Mr. and Mrs. Bogart, good name for a couple that owns movie theaters, they had a contract. They had purchased movie theater from Caldwell, and in that agreement was a do not compete clause. Caldwell was not supposed to open another movie theater in town. Okay?
Caldwell goes ahead and opens another movie theater.
After Mr. Bogart dies, the contract was with Mr. Bogart. Mrs. Bogart takes over the contract. She sues Mr. Caldwell and says, you know, you're not supposed to do that under the contract. And he says, who are you? My contract was with Mr. Bogart. That's strictly personal. Is it?
Court says heritage.
Right. So almost all obligations are heritable or assignable. In this case, she inherited it. But what if she had assigned it to her granddaughter? Would Mr. Caldwell still be obligated? Yeah. Yeah, as long as it's still the same entity, yeah.
So in order for it to not be able to be inherited, would be if that contract would specifically said
It's personal
to him.
him. Or if it were a different kind of contract, like the ones that I was talking about before. Okay. LaRocca versus LaRocca. Divorce is strictly personal, except when it isn't, right? Isn't that sort of the moral of this case? Ms. Jacob, you want to talk about it?
Okay, so Isabel was her name.
Mm-hmm.
She had her and her husband Carlo were going through a divorce, and they had actually filed. I think she had filed recreational demand
Mm-hmm.
based on adultery, and then she died while it was being appealed.
Right. Now, as part of her reconventional demand, what is she asking for?
Her donations back. She had donated some property.
Right. Now, if you think somebody is cheating on you, do you think you can demand the stuff back that you gave to him? Well, ingratitude, right? Cruel. Could be pretty cruel. Not taking the life, attempting to take the life of someone. So she dies, and this is up in the air, and normally it would die with her, but
She had 3 children from another marriage who had interest. Well, the divorce would affect their interest in the property.
right. And because their interests are important, we can't dismiss it, even though it would normally be a strictly personal thing. Okay, you talked about, I'm going to give you an introduction to suspensive and resolutory conditions because it's easy to get backwards. 1772. Okay. What is a condition? What is a condition? Any idea what a condition is? Let's see, let's go back to Article 1767. It's more accurate. What is a condition? An obligation with a condition. Right, it's an obligation that depends on an uncertain event. Either if the uncertain event happens, you won't have an obligation, or if the uncertain event happens, you will have an obligation. It can work only one of two ways. Okay? So if it rains tomorrow, I tell my son, you don't have to mow the lawn. Okay? If it doesn't rain, you do. What's the uncertain event on which his obligation depends? If it rains or not. If I smack into somebody's car, insurance company, you have an obligation to pay up and defend me in court. Okay? If I don't, then you do not. Okay? An obligation that doesn't come into existence until the thing happens is called suspensive. It's called suspensive. It's suspended in the air, okay? And it's only when the uncertain event happens that it comes banging down on your head. If you visualize that, it will be easier to remember which is which. Suspensive obligation is one that's suspended in the air until the uncertain event occurs, like with the insurance. If the obligation may be immediately enforced but comes to an end when the uncertain event occurs, then it's resolutory. You are obligated to come to work until such time as you decide you don't want to be employed here anymore. Okay, your decision that you don't want to be employed here anymore is a resolutory condition. That's an uncertain event, right? Okay. So at-will employment depends on the employee and the employer, depends on resolutory conditions.
Could you define that for you, the example just a moment ago?
Resolutory, obligation starts right away, ends with the uncertain event. Okay? If I were to tell my kid, yeah, I can see it's threatening to rain, but I really want the lawn mowed, so you keep mowing until the rain hits. Okay? You have to mow until it starts raining. That's resolutory. The other one is the opposite, suspensive. No obligation until the uncertain event happens. So the uncertain event is suspended in the air. Okay? So the rest of that section that we're going to be starting on Wednesday and going forward about 30 pages. Okay? Yes? Okay. And let me stop this and